Good morning and welcome to the Maryland Public Service Commission's administrative meeting for October 13th, 2021. We'll begin with approval of the minutes from our last meeting on October 6th, 2021. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The meeting minutes are approved. Good morning, Mr. Secretary.
Morning, Mr. Chairman. There are 5 items on today's consent agenda. Item number 1 is an unbundled network element loop forbearance agreement to an interconnection agreement between Verizon Maryland LLC and IDT America Corporation. Item number 2 is a notice of discontinuance from AT&T Corp. Of all-in one local exchange service for business customers. Item number 3 is a notice from Great American Insurance Company of cancellation of bond for Hovey Energy LLC. Item number 4 is an application from Butterfly Inc. for a license to supply electricity. And finally, item number 5 is a notice of customer assignment from Major Energy Electric Services LLC.
Thank you. Do any of the commissioners have questions? Commissioner O'Donnell.
Hi, is someone from staff online that can maybe answer a question about item number 5?
Morning, Chairman, Commissioners. Nan Zhang on behalf of staff.
Good morning, Ms. Zhang. So I wanted to ask about the company. We're transferring these 800 and some the companies are transferring 800 and some customers and residential and 20 some residential customers. And we sanctioned this company in 2016 for $250,000, I believe, if memory serves me correct, for unsavory practices. And yet there seems to be in the last 3 years some significant complaint history with the company that's receiving these customers. Do we have any explanation of why that's acceptable? Or I mean, these are serious complaints.
I don't know the answer to the question, but
No problem. Maybe it's more appropriate for me to ask the company because I didn't realize they were here. So let me ask the company that same question if the company could respond.
I understand we have 2 representatives from the company, from Spark Energy and from Starion. Are they with us on the line? Seeing no representatives from the applicant here, Commissioner O'Donnell, would you like to hold this over?
Yeah, I'd like to hold this, Mr. Chairman, until the company can come in and explain to us their complaint history, if that's possible.
That's more than possible. I understand we were supposed to have a Mr. Bassett and Mr. Joseph with us, but I do not see them here today. Ms. Zhang, do you know the status of counsel or representatives for the entity?
I'm not sure. I don't know.
That's fine. That's fine. We'll treat them as a no-show for today, and we'll delay this for a future meeting. Any additional questions on the consent agenda items? Seeing none, I would move that with respect to item number 1, that we note the amendment. With respect to item number 2, that we note the filing. With respect to item number 3, I move that we cancel the company's electricity supplier license. And with respect to item number 4, I move that we grant the company Butterfly Incorporated a license to operate as an electricity supplier in Maryland limited to aggregator services for the customer services and territories applied for and recommended by staff, and direct the company to file notice with the commission within 30 days of any changes to the information in its application. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motions are approved. Mr. Secretary, the administrative agenda, please.
Mr. Chairman, the only item today is item number 6, which was held over from the October 7th administrative meeting, consisting of a proposed delivery interconnection agreement between Washington Gas Light Company and Washington Suburban Sanitary Commission. On this item for staff, we have Negusi Tesfaye, Lloyd Spivak, Ken Albert, and David Hoppip. For WGL, Paul Buckley and John Dodge. For Office of People's Counsel, Joe Cleaver. And for WSSC, James O'Day.
Thank you. Welcome back to the parties. We received a pleading yesterday from Mr. Buckley at Washington Gas Light. It appears that the parties have settled out almost every matter, with the exception of OPC's protest regarding environmental remediation costs. Is that correct for the parties, beginning with staff?
That is correct. David Hoppick on behalf of staff.
Thank you. For Washington Gas, I saw Mr. Dodge nodding. Is that correct, Mr. Buckley, Mr. Dodge?
Yes, it is, Your Honor.
Okay. And Mr. Cleaver, is that correct?
That's correct, Your Honor.
Okay, so we have the one item left, OPC proposed condition C as in, nope, sorry, E as in echo regarding environmental remediation costs. Mr. Cleaver, would you like to respond to Washington Gas's statements from yesterday?
Yes, Your Honor. Thank you. Your Honor, first, I would just say that OPC appreciates the cooperation that occurred between staff, the company, and OPC to reach agreement on all of the other outstanding issues beyond the one that I'm about to address. And we spent a lot of time working through those disagreements. We're able to reach compromise on pretty much everything except for this issue. And we had to agree at the end that we weren't going to reach agreement. This condition, OPC recommends that the commission, if the commission approves the agreement, that the approval should include an express condition that any environmental remediation costs incurred under Section 5.8 of the agreement are not recoverable from any Washington Gas customer other than WSSC. And Section 5.8 of the agreement, it says a lot. There's a lot of words there, but I thought it may be helpful to very briefly break it down. It really says 6 things. The first thing it says is that no environmentally deleterious substances is currently at or will be stored, leaked, spilled, deposited, conveyed through either facility or otherwise released on either facility. So that it makes both parties make that representation. The second thing it says is, notwithstanding that representation, parties are allowed to store those materials that are customarily associated with their operations, whether it's construction or maintenance. And it includes a list. It's not exhaustive. It says not limited to, but it says oil, petroleum products, and wastewater sludge. The third thing that Section 5.8 says is that in the event of a release of an environmentally deleterious substance, that the party who discovers the release will notify the other. The fourth thing it says is that if any party breaches the agreement, it has this provision, 5.8, that party has full responsibility for the cleanup and must indemnify the other party. And that's for both facilities, regardless of which facility is contaminated. The parties have to indemnify the other party if that party was in breach of any of the covenants of the agreement. The fifth thing it says is that if both parties breach, they share the costs. And the sixth thing it says is that this section shall survive the termination of the agreement. So what this section does is it binds Washington Gas in perpetuity to indemnify WSSC for any environmental remediation costs that WSSC may be responsible for in the event that those costs were caused by Washington Gas's breach of any covenant in Section 5.8, specifically that none of these substances will be stored, leaked, spilled, deposited, conveyed, or released on either facility. So as we review this provision, Your Honor, we see this as imposing a new and unknown risk on Washington Gas customers. Washington Gas has assumed this indemnification agreement, and that's a risk that customers don't presently face. In its comments, staff's recommendation on this particular point is to wait to determine the appropriateness of cost recovery, and that can be evaluated when and if WGL seeks cost recovery. And it's true that there are, in the event that this came up 5, 10, 15 years down the road, OPC's position is that there would be defenses available. Specifically, in the event that Washington Gas becomes liable under this language, OPC would likely argue that it wouldn't be a necessary and proper expense. OPC would likely challenge the prudency of Washington Gas's actions, And also, I would acknowledge that Section 4211 of the Public Utilities article does say that if a court of competent jurisdiction determines that the proximate cause of environmental contamination for which a utility is responsible is a result of the gas company's failure to comply with a state or federal law, regulation, or order, then those costs are not recoverable through the utility's cost of service rates. But Your Honor, with respect to the first 2 points, unknown which commission will hear this, who will be on the commission at that time. With respect to the third point, this could be, Washington Gas could accrue liability under this provision, even if it doesn't violate any environmental law. It could just be due to basic negligence that Washington Gas could potentially become liable under this provision. And plus, there's no guarantee that a court of competent jurisdiction would rule any given way, and it could be a long and difficult process to obtain such an order. So Washington Gas has come before you with this contract and asked you to approve it. And OPC's position is that it would be a reasonable condition for the commission to place on its approval of this contract to say that those costs that Washington Gas becomes responsible for under Section 5.8 of the agreement won't be recovered from customers. That's a very reasonable condition to put on this contract. It protects Washington Gas's other customers from this new risk, and not asking for any change to the contractual language. Certainly not asking Washington, you to have Washington Gas and WSSC go back and renegotiate this provision. It can continue to say what it says, but OPC's view is that the commission should condition its approval of this agreement on that restriction in terms of future cost recovery on the very limited type of costs that may arise under this provision.
Thank you, Mr. Cleaver. I believe we're clear with respect to WGL's position on your argument as well as staff's position. Do commissioners have questions of counsel? Commissioner O'Donnell, if you could take the mic.
Thank you, Mr. Chairman. Mr. Cleaver, I'm not a lawyer and you know that, but I'm going to ask you a legal question anyway. Why shouldn't I assume as a commissioner that you're asking me to do a single issue rate making decision with regard to this issue ahead of any attempt to recover on the part of the company? I mean, this feels like to me, as a member of the commission for 5 years now, that it's a single issue rate making decision. Why shouldn't I view it that way?
Your Honor, I think the fact that this is a special contract, I think changes the analysis. None of the provisions in this contract that address how rates will be devised, what the rates will be, who will bear responsibility in certain situations, what will happen under different scenarios. Those aren't generally applicable conditions that apply across a given rate class. This is an arm's length contract negotiated between two parties that is unlike any other rate relationship that the company has with any of its other customers. And in fact, that's why there isn't a rate discrimination issue here, because there is an exception in that statute for uniquely situated customers, and that is the basis on which the company has entered into this agreement with WSSC. So if the commission were to say, we've reviewed this contract, we find it reasonable, but this particular provision, in our view, imputes additional risk to existing customers. So we want to be clear up front that based on this language and based on how those costs could arise as described in this provision, in other words, through Washington Gas's breach of these covenants, we want to make clear to Washington Gas at this point in time that it would not be appropriate to recover those costs from any other customers. There's no scenario under which
I
it would be
understand,
appropriate.
I understand your argument. I appreciate your argument, but it feels like this is like opening the door to putting a whole bunch of conditions one at a time, kind of a la carte through AM proceedings into future rate making proceedings. And I just can't in good faith do that. You by your own argument acknowledge you'll have a remedy later. And you've already said what your arguments would be in such a case, should they develop later. But I don't want to start going down the path of adding a la carte rate making decisions in AM proceedings before the company's ever even sought to recover costs on them. I just find that a difficult pill to swallow.
Your Honor, I understand the concern and I appreciate the question. I would just add again, at the meeting last week, we talked a lot about the language, you know, and the standards applicable to special contracts. Specifically, bear with me a second, Your Honor, I'm looking back through my notes from last week to find the clause, but you know, there's the language that this language, while the commission understands that special contracts may result in cost shifting, it will not permit excessive rate increases for other customers. Accordingly, it may be appropriate in some instances for shareholders to bear some of the burden for these special contracts. And that's from the 1995 order that was discussed frequently last week. That's Ray Electric Services Market Competition and Regulatory Policies 86 PSC 271-288. Your Honor, this is a scenario
I appreciate that. I'm suggesting that maybe we'll cross that bridge when we get to it.
And I understand your point, Your Honor, but this special contract today is before this commission, and it's in this context of an administrative meeting, and this is this commission's opportunity to look at this special contract and to say, you know, this is fine, except for this provision. There's no scenario under which Washington Gas's cost responsibility under this provision would be triggered, where it would be appropriate to recover these costs from other customers. I mean, if Washington Gas hooks up some new customer under, you know, say GSP 14, whether it's an economic project or whether the customer makes a contribution, and say it's me and I'm just a standard residential customer that's, you know, going forward included in that rate class, Washington Gas doesn't enter into an indemnification agreement with me and tell me that they'll indemnify me for any hazardous substances released on my property, you know, that could be connected to some activity that I'm engaged in or that they're engaged in, if it's their fault for releasing the substance. So this is a very different scenario than your typical customer that comes onto the system. And that's
I hear you, Mr. Cleaver. I just let me take the obverse of this, of my kind of feeling on this. Are you suggesting that by approving this contract, by approving this item and rejecting your argument on item E or Echo, that we're approving cost recovery? Because I don't see it that way. We're not approving cost recovery for this item. That would be single issue rate making. So if the obverse is true, then my position has to be true.
I understand the point, Your Honor. I'm not sure I'd go so far as to agree with the conclusion that you just stated. No, I don't believe that by approving this with either what, you know, with the proviso that, you know, this can be addressed later to the extent that it arises, I don't believe that would constitute a pre-approval of the costs. But again, the point I would make is that, you know, this is you know, before this commission now, and that there's no sequence of events under which Washington Gas would accrue liability under this provision where it would be appropriate to recover the costs from its other ratepayers. I mean, there's just no scenario under this provision. Again, not talking about some other environmental remediation costs somewhere else in the service territory, or even on Washington Gas's own property here, that doesn't implicate section 5.8. So that's why the limitation is, excuse me, that's why the recommendation is limited to section 5.8. And yes, Your Honor, I candidly acknowledge that there are defenses that would be available to OPC. I mean, if this ever happens, I don't think it will. I don't hope, I hope it doesn't. I don't think it'll ever happen. But to the extent it happens, I might not be here. None of us may be here. And it's, I don't know. Obviously, none of us can know how the commission would treat this in some case 10 or 15 or 20 years down the road, or if you read this language, 75 years down the road. It just
Mr.
doesn't
Cleaver,
seem appropriate. Yes.
I find that you make a very reasonable argument here, but at this point in time, I cannot possibly conceive every instance that would necessarily shield ratepayers from possibly sharing in the remediation costs. I can't think of any, and I think you're probably right that these remediation costs should be borne by either this customer, WSSC, or WGL. But I agree with the position of staff that this will be a case-specific examination at the appropriate time, if and when, and hopefully not, some type of environmental remediation becomes necessary due to negligence, breach, or otherwise. If it is due to the liability of either the pipeline or the customer, I would fully expect that the commission at some future date would recognize that and appropriately allocate those costs. But at this time, I'm not prepared to support the argument of People's Counsel. Do additional commissioners have questions? With respect, I'm just going to take a informal poll of the commissioners. Do any commissioners support OPC's position with respect to environmental remediation costs?
I think it-
Commissioner Richard notes that he supports the position.
I was going to offer a amendment to
Oh.
the motion, but would you? I'm fine. Just, I think that the votes are here, but no, I agree with Mr. Cleaver's argument. If this contract is supposed to mean anything, the company has taken on the responsibility, the risk. And so if they're doing that here, I don't think they should be doing that on behalf of all the ratepayers at this point as well. So since they've already closed the door, well, I think they should have closed the door since it's in their contract. I believe that the condition that the OPC is offering makes perfect sense, and we ought to accept it. And not, otherwise I don't know what the contract means. So I would support OPC.
Are you making a formal motion?
Well,
Would you like to make a motion?
sure. I move that we include OPC condition E in your motion, which you have not made yet. Okay.
We'll take a vote on your motion. That vote begins with Commissioner Herman,
Nay.
Commissioner Linton, Commissioner O'Donnell,
No.
Commissioner Richard made the motion, which was aye. I vote nay. The motion fails. I would move that we accept the negotiated contract subject to the conditions recommended by staff in its comments dated September 22nd, 2021, and revised as noted in WGL's reply comment dated October 12th, 2021. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton, Commissioner O'Donnell,
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved. Before we conclude today's proceedings, we do have our mid-course evaluation and semi-annual evaluation hearing with respect to electric vehicle charging. That will begin at 10:35 a.m. this morning on this channel, 10:35 a.m., case number 9478.